courtroom was silent before anyone spoke. Not the silence of respect. The silence of completion. Daniel Harper sat at the defense table with his hands folded tightly in front of him. Not praying. Not pleading. Containing a tremor that would not stop. His eyes moved slowly across the room. Judge, jury, prosecutor, bailiff. No one was looking at him with curiosity. They were looking at him the way people look at a closed file. The air felt heavy, pressurized, like the moment before a door seals shut. Daniel noticed it then, not later, not after the verdict. Right there, this was not a room waiting for answers. This was a room waiting to confirm a decision already made. The judge entered. The jury stood. The routine unfolded with mechanical precision. Nothing felt rushed. Nothing felt uncertain. The prosecutor did not look at his notes. He did not need them. The case had already been decided somewhere else. Daniel's alibi had been entered into the record. Time-stamped phone logs, confirmed witnesses, utility data showing activity inside his home during the time of the robbery. None of it changed the temperature of the room. Witnesses contradicted themselves openly. Heights shifted. Clothing descriptions changed. Timelines bent. Each inconsistency landed without consequence. No one leaned forward. No one asked why. When the defense objected, the judge listened patiently, then denied. Again, and again, each denial tightened the space around Daniel's chest. The evidence did not collapse. It was allowed to stand crooked. Daniel felt something settle in his stomach. Not fear, recognition. He understood then that trials were not always about truth. Sometimes they were about maintenance. Welcome to Crime Escape Chronicles, the channel that handles unsolved mysteries, shocking crimes, hidden truths, real secrets, injustice, real danger. Can you handle what's coming next? His name was Daniel Harper, 32 years old, no criminal history, no disciplinary record, no reputation beyond reliability. He worked as a clerk. He filed documents. He followed procedures. He lived alone. He paid rent early. He avoided attention. That mattered more than anyone admitted. Because when a convenience store clerk was shot just after midnight, the city needed speed. The police needed certainty. The media needed a face. The neighborhood needed reassurance. Daniel lived 3 blocks away. That was enough. The crime scene was chaos. Officers arrived in waves. Tape went up late. Footprints were destroyed. Witnesses were interviewed in clusters. Stories blended before they were recorded. A security camera failed at the wrong moment. Another camera caught 2 figures running. Neither resembled Daniel. The footage was described as unusable. Someone mentioned a quiet man who lived nearby. Someone else remembered seeing him before. The detail hardened. The name stuck. Daniel was arrested without warning. He was arrested at work, in front of people who had never seen him raise his voice. The detective spoke calmly. Professionally, they said this would clear up quickly. It did not. Once his name entered the system, the investigation narrowed, not forward, but inward. Evidence that complicated the narrative slowed. Evidence that supported it moved fast. Witnesses were re-interviewed. Their stories shifted closer together. Statements became cleaner, more confident. A man who originally said he could not see the shooter's face later testified. He recognized Daniel immediately. No one asked what changed. The courtroom filled each day. Cameras lined the walls. Headlines hardened before testimony finished. Daniel watched his own image appear beneath words like killer, suspect, monster. He stopped looking at the screens. The prosecutor spoke with finality. Each sentence delivered as conclusion rather than argument. Daniel's defense tried to introduce doubt, to stretch timelines, to explain inconsistencies. The judge allowed them to speak, then removed their impact. Expert testimony that suggested another suspect was limited. Cross-examination was curtailed. Jurors were instructed to focus on the narrative presented. Daniel spoke once. He said he was home. He said people saw him. He said records existed. His voice sounded smaller than he expected. The room absorbed nothing. From the gallery, his sister Rachel watched everything. She did not cry. She did not interrupt. She wrote everything down. She noticed what the court ignored. Witnesses changing details mid-sentence. Evidence referenced without being shown. The way the jury looked bored during defense arguments. She called lawyers during breaks. She emailed innocence organizations. She filed motions on his behalf. Responses came slowly, if they came at all. The system was already moving forward. Weeks before closing arguments, the case cracked open. Fingerprints recovered from the store counter were confirmed not to be Daniel's. DNA pulled from beneath the register excluded him entirely. A witness admitted privately to being pressured by police to adjust testimony. The defense submitted emergency motions. They were denied. The judge ruled the evidence unreliable, then refused to allow the jury to hear about it. The contradiction stood. Evidence that excluded Daniel was too weak. Evidence that implicated him was sufficient. The message was clear. This was not about accuracy. This was about completion. On the final day, the courtroom felt different, heavier, colder. No one whispered. No one shuffled. The jury returned quickly, too quickly. Daniel stood as instructed. He barely heard the words at first. His body reacted before his mind. Guilty. The sound did not echo. It landed. The sentence followed without pause. Death. Rachel made a sound that cut through the room. A short, sharp breath. Then silence. Daniel did not resist when they took him away. He fell hollow. Death row erased time. Lights never fully went out. Sounds never fully stopped. Names disappeared from cells without explanation. Daniel learned the schedule by feel. Meals, counts, lock clicks. He stopped marking days. Appeals were filed. Delayed. Returned. Denied. His lawyers spoke carefully. They avoided promises. Rachel wrote constantly. His mother wrote cautiously. Their letters tried to sound normal. Daniel memorized them. The execution date arrived quietly. No announcement, no warning. The night before, Daniel did not sleep. He sat on his bunk with his back straight. He forced himself to remember ordinary things. The smell of paper, the weight of a pen, the sound of rain hitting a windshield. He thought about the evidence that never reached the jury. He thought about the man who actually committed the crime. Untouched, unknown, free. Morning came without ceremony. He was escorted down a hallway he had walked only once before. Straps tightened, paperwork signed, needles prepared. No one asked questions. No one hesitated. The injection began. Daniel Harper died without confession because there was none. The system recorded the outcome. The file was closed. Daily headlines read justice served. Later, reports surfaced. Mishandled evidence. Witness coercion. Forensic exclusion ignored. Judicial obstruction. Legal analysts spoke in careful language. Nothing changed. Rachel stood before microphones once. She did not cry. She said the evidence existed. She said no one listened. The crowd dispersed. The courtroom moved on. Another case replaced his. The record remained. Somewhere in the files, the truth sits documented, unread. The verdict was reached before the trial began. The cost was permanent. and the silence that followed was not peace. It was erasure.